The Judiciary will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight of the U.S. Copyright Office. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I'd also like to ask all members to please mute your microphones when you are not speaking. This will help to prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. Copyrights have played an integral part in driving this country's standing as a leader in creativity and innovation. The idea that creators should reap the rewards of their hard work dates to the country's founding, when in Article 1, Section 8 of the Constitution, the founders granted Congress the authority to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. While copyright laws evolved over the years, our goal is to remain true to the underlying aim of promoting and incentivizing creators' hard work by protecting their intellectual property. This has largely been a success. Today, core copyright industries account for millions of jobs and have contributed more than $1 trillion to the U.S. economy. The U.S. Copyright Office, the focus of our hearing today, plays a vital role in upholding this copyright system. I'd like to extend a warm welcome to the Register of Copyrights, Shira Perlmutter, who is at the helm of this important institution. Register Perlmutter is 6 months into her tenure as Register, and we look forward to hearing from her today and to working with her on the many issues before the office and in the copyright space. This past year, as the nation adjusted under the coronavirus pandemic, the Copyright Office likewise had to adapt. In March 2020, the office transitioned most of its staff to remote work and offered electronic options for services that were previously paper-based. The office also used its authority under the CARES Act to extend the deadlines for certain actions. I commend the office for its work in transitioning smoothly. This past year also has highlighted the importance of an effective and robust copyright system. Just as the Copyright Office had to close its physical doors, music concerts vanished, theaters shuttered, and movie sets were inactive. This has had a devastating impact on creative industries and has made it even more evident how critical it is that we maintain a strong copyright system to bolster the creative community as it seeks to recover in the face of the pandemic. This committee held its last Copyright Office oversight hearing in 2019. There have been some notable changes since then. In December, for example, Congress passed the Copyright Alternative in Small Claims Enforcement Act, or CASE Act, led by our colleague Representative Jeffries and our former colleague Representative Doug Collins. The CASE Act addressed the prohibitive costs of pursuing a copyright infringement suit in federal court by establishing a small claims tribunal in the Copyright Office called the Copyright Claims Board. The board is expected to be operational by the end of the year, and we look forward to hearing about the office's progress in implementing the CASE Act and standing up the board. The Copyright Office has also been integral in the implementation of the blanket license for digital music providers established under Title I of the Music Modernization Act. The blanket license became available this January, and the Mechanical Licensing Collective has already distributed its initial round of royalty payments. We look forward to hearing more about how the first few months of the blanket license have unfolded so far. Turning to what may lie ahead, this is the committee's first opportunity to hear from the office about the report on Section 512 of the Digital Millennium Copyright Act that it published last year. The office reviewed whether in today's environment, Section 512's notice and takedown regime properly balanced the growth of the internet against the protection of intellectual property rights. The office concluded that this balance was tilted askew. The office put in a tremendous amount of work over the course of its multi-year study, and we look forward to discussing the office's conclusions and recommendations. I'm also interested to hear Ms. Perlmutter's views on the ART Act legislation I introduced responding to the office's recommendation in the 2013 report that Congress consider creating a resale royalty right for visual artists that would give artists a percentage of the sales when their work is resold under certain conditions. This addresses the disparity that arises in the field of visual arts because such artists do not benefit from the copyright system in the same way as other creators, since they generally do not sell many copies of their works. This legislation ensures that if their works become more valuable over time, they are able to share in that increase in value. Accordingly, I believe this legislation is a matter of basic fairness and would put us in the company of more than 70 other countries around the world. It would also ensure that Americans receive royalties when their works are sold abroad in those other countries, which will not happen until we offer them such a right ourselves. Moving away from the law, the committee is also following the Copyright Office's efforts to modernize its IT systems and business processes. The office made a number of updates last year, including launching an electronic recordation pilot and releasing a new public records interface. The Library of Congress is also convening a Copyright Public Modernization Committee to be led by the Library of Congress's Office of the Chief Information Officer. The committee looks forward to hearing about these and other developments at the office and in the copyright system. I thank Register Perlmutter for her appearance today, and again, I congratulate her on her appointment. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, it's May 5th, and this is our first full committee hearing. There's a crisis at the border. The president is talking about abolishing ICE. Our local communities are being threatened by the left's movement to defund the police. You're trying to pack the Supreme Court. The teachers union are stopping kids from going to school. President Biden is bankrupting the country one omnibus bill at a time, and a virus continues to threaten our civil rights. But the House Judiciary's first full committee hearing this Congress is oversight of the Copyright Office. Now, look, we mean no offense to Register Perlmutter and the important work her office is doing. In fact, copyrights are a critical part of the U.S. economy, and it's an area ripe for bipartisan work. America's creators and distributors deserve our attention to make sure this is a well-functioning marketplace. We're all proud of the major pieces of copyright legislation that were signed into law in recent years, some that the chairman just talked about, including the Music Modernization Act and the CASE Act. And hopefully this is just the beginning. Last Congress, we began important work looking into Section 512 and other areas of the DMCA that can be improved. And it is our hope that consensus legislation can be identified and actually signed into law. We must keep a watchful eye over the collection and distribution of unclaimed royalties under the Music Modernization Act to ensure that trade associations and big publishers and wealthy artists are not profiting out on the back of those without the means to access the money that they are owed. Rampant online piracy of copyrighted movies, TV shows, music, and other content by criminals in China, Russia, and elsewhere must also be stopped, and bold steps taken to fight it, such as the felony streaming law we passed late last year. We must continue to look for ways to improve and modernize the copyright system so that it can continue to be the engine for job creation and economic growth for decades to come. I look forward to working with the Copyright Office. We've had a nice conversation with Ms. Perlmutter to take action on all of these vital issues, and appreciate that this hearing is an opportunity to help that along. But I hope that the chairman will finally start to pay similar attention to the many urgent problems facing Americans today, problems I hear about every single time I'm out in our district, as I am today, and as many of our colleagues are, problems that Americans want us to address, want us to deal with. I hope we get to them soon, Mr. Chairman. And with that, I yield back.
Thank you, Mr. Jordan. Without objection, all other opening statements will be included in the record. I will now introduce today's witness. Shira Perlmutter is the Register of Copyrights and Director of the U.S. Copyright Office. She was appointed to the position effective October 25th, 2020. Prior to her appointment as Register, Ms. Perlmutter had served since 2012 as Chief Policy Officer and Director for International Affairs at the United States Patent and Trademark Office. Before joining the USPTO, she was Executive Vice President for Global Legal Policy at the International Federation of the Phonographic Industry. Prior to that, she was Vice President and Associate General Counsel for Intellectual Property Policy at Time Warner, and previously, she served as the first Associate Register for Policy and International Affairs at the Copyright Office. Ms. Perlmutter received her bachelor's degree from Harvard University and a law degree from the University of Pennsylvania. We welcome our distinguished witness and we thank her for participating today. I will begin by swearing you in. If you would please turn on your audio, make sure I can see your face, and you raise your right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God?
I do.
Let the record show that the witness has answered in the affirmative. Thank you. Please note that your written statement will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timer on your screen. You may now begin.
Chairman Nadler, Ranking Member Jordan, and members of the committee, thank you for the opportunity to discuss the many activities and accomplishments of the U.S. Copyright Office. I'm pleased to report that the office has shown remarkable resilience during this challenging year. We continued to provide high-quality services to the public and expert advice to Congress and executive agencies, and achieved several milestones in our modernization efforts. We also moved forward in implementing recent legislation and have even improved processing times for electronic submissions. I'll describe our major current initiatives, report on ongoing work, and outline our high-level priorities moving forward. First, we've made great strides in implementing the landmark Music Modernization Act, or MMA. The office completed the initial regulatory framework required for the Mechanical Licensing Collective, MLC, to administer the new blanket license. We've also fully implemented Title II, which provides protection for pre-1972 U.S. sound recordings. And we're concluding a study on best practices for the MLC to locate copyright owners and encourage the claiming of unmatched royalties. Second, we're working intensively on implementing the CASE Act, which establishes the Copyright Claims Board, which will be the first ever IP small claims tribunal in the United States. The office has issued a notice soliciting public comment on features of the new system and a proposed rule establishing a process for expedited registration for claims pending before the board. We're close to making recommendations to the librarian for the appointment of the 3 copyright claims officers. We're collaborating with other units in the library to ready the technology and office space that will be needed for the board to launch. And we've developed a dedicated web page which sets out the key facts about the tribunal and its status. Finally, we've made significant progress on office modernization. In fiscal 20, we met objectives on 3 major work streams: the launch of an electronic recordation pilot, the release of a new interface for the copyright public record system, and the internal release of a clickable prototype of the planned new registration application. We're in the process of digitizing our historic public records, and we moved into a new warehouse where we will be consolidating all of our copyright deposit materials. Let me turn to other ongoing work. The office quickly adapted to the pandemic, transitioning 98% of the staff to full or partial telework within just a few weeks. The bulk of our operations have been largely unaffected by the transition. In fiscal 2020, we registered nearly 450,000 claims to copyright involving millions of works. Even with the pandemic, we significantly reduced our processing time for examining most claims. We maintained an effective e-deposit program for the library, with the value of deposits just shy of the previous year's total. And the office continued to provide legal and policy advice, including the report on Section 512. We've issued numerous rules and regulatory proposals since the start of the fiscal year, participated in several high-profile litigations, and continued our international work in multiple venues. After a virtual listening tour with a wide range of stakeholders, I've identified several high-level priorities going forward. First, we will ensure that office modernization is not a one-off event, but a process of continuous improvement. Once we've fully digitized our collections and records, we will leverage that trove of data for the public's benefit and utilize new platforms and new technologies. Second, we will work to open up the copyright system further to more participants. We want copyright to be as accessible as possible. and that will include broadening our outreach and education efforts and focusing on underserved communities to expand diversity. Third, we will enhance the office's development and use of data by adding economic expertise. We will be hiring a chief economist to assist in producing and analyzing factual evidence for decision-making on both policy and financial matters. In sum, the office's 150th year has been exceptionally busy and challenging and productive. I want to thank our dedicated staff for all their work to serve the copyright community and the public, especially during the pandemic. We appreciate this committee's continued support of the office and its mission. Thank you.
Thank you for your testimony. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Last May, the office released its report on Section 512's notice and takedown regime, which preceded your appointment as Register. Now that you are the Register, do you concur in the report's ultimate conclusion that the balance Congress intended to strike in Section 512 has been tilted askew? And is there anything you would add or change in the Section 512 report?
The Copyright Office report was a comprehensive and thoughtful analysis after 5 years of gathering input and looking at judicial interpretations and data. I agree with its conclusions and recommendations. As the report set out, the original goal of Section 512, and I should add that I was at the Copyright Office assisting Congress in drafting the initial legislation. The goal was to find the right balance between the stakeholders in the online ecosystem to ensure that copyright owners could effectively enforce rights in the online environment, but also at the same time ensure that service providers had legal certainty to be able to offer innovative platforms without facing crippling liability for the actions of all of their users. And then, of course, users' interests were reflected in various ways, in part through the putback provisions for content that was improperly taken down. Now, in many ways, Section 512 has achieved those goals, but more than 20 years later, there have been a lot of changes in practices, in markets and technologies, and of course, as the court interpretations have evolved and been applied. So the result is that, as the Copyright Office outlined in its report, at least for the copyright owner community, the expected results are not today what they were hoped to be. And it has become more difficult to assert rights than was originally anticipated. So what we hear primarily is what's often being referred to as a whack-a-mole problem, with the issue that as soon as content is taken down under the system, it may be immediately reposted. And then there are challenges for small copyright owners in monitoring the huge amount of content on the internet and being able to locate and address infringements of their works. On the other side, while service providers and consumer groups in general think the system is working well, they also have noted some concerns, including about potential abuse of the system and what the impact might be of automation as it is increasingly utilized, in particular on free speech interests. So I do think there is room for adjustment. The Copyright Office did not make very specific detailed recommendations, but pointed to areas where Congress could profitably act to restore the originally intended balance, or potentially to change it in some ways to adapt to new circumstances. I think all of those proposals are well worth continuing to discuss and to pursue.
Thank you. In 2013, the registrar at the time, Maria Palante, submitted to this committee an updated analysis of the resale royalty issue, in which he stated that Congress may wish to consider a resale royalty for supporting visual artists. I believe you've been studying this issue since your time as a law professor. Do you agree with Register Palante's assessment?
I do. As you have noted, I have been personally supportive of the concept of resale royalties since early in my career. I believe there are very good policy arguments to adopt such a right. And since I first studied the issue, more and more countries have adopted such a right. I think now around 70, as you noted in your opening comments. And there is also more evidence about the impact of such a right, showing that some of the concerns about its adoption and some of the potential negatives have not materialized. So I do support continuing to look at this. I note that the ART Act from the 115th Congress reflected a number of the points made in the Copyright Office's report, and especially given the office's recent experience with implementation of the MMA and the CASE Act, we would be happy to contribute some technical assistance, drawing on those experiences to work with the text and be of assistance.
Thank you. Recognizing that the Copyright Royalty Board operates independently from the Copyright Office in terms of its rate and distribution and adjudication proceedings, I'm concerned about reports from the creative community about a backlog in commencing proceedings and ordering the distribution of royalty payable to claimants. How can Congress and the Copyright Office work together to ensure the CRB reduces the backlog and distributes royalties in a timely fashion moving forward?
Yes, that's an important question. Thank you. The main thing that Congress can do to help the CRB, I believe it's already done, and that is to remove the previous statutory cap of 3 people on the CRB's staff, and the approval of the CRB's funding request to enable it to add those additional staff members. So that should help a lot with the workload going forward, but it will take some time for those effects to be fully felt. I think it's important to note that the current caseload of the CRB is really unprecedented. It's dealing with 2 remands from the DC Circuit, which mean that the judges are handling 3 of their most complicated rate-setting proceedings simultaneously. And there has also been some impact of the pandemic, which has caused some delays because of adjustments needed in process. For example, some of the hearings were delayed a number of months because they had to be conducted virtually, and the CRB was not equipped for that previously. But I do think it's worth mentioning that I understand from the judges that they've actually authorized a greater sum of royalties for distribution in FY 2021 to date than the amounts that were authorized in any of the last 6 years. So there are some positive changes. And we will continue to monitor the situation and consult with the judges to see whether there are any additional structural changes or adjustments that could be helpful in improving efficiency.
Thank you. My time is expired, Mr. Shabbat.
Thank you, Mr. Chairman. And before I ask a few questions of our distinguished witness here today, I'd like to make a point, as the ranking member, Mr. Jordan, did previously, that this Congress was sworn in over 4 months ago, and the Democrats and you, Mr. Chairman, have had complete control of this committee for all that time. And this nation has faced a number of crises, perhaps most significant, the crisis at our southern border, which it's been completely self-inflicted by the Biden administration, I might add. The so-called kids in cages issue, which was used to bludgeon the previous administration. And it turned out the photographs that were released were actually taken during the Obama administration. Well, those policies and the kids in cages continued through this administration, the Biden administration. Now they're trying to peddle the story that it's better. But these kids and thousands of adults too, they've merely been put on buses, in planes, and shipped around the country. Some have been given court dates, but as it turned out, statistics show that over 90% of the people never show up for their court dates. So they're basically just released into the population. This border crisis is a huge problem, something that's actually within the jurisdiction of this committee, yet not one hearing in 4 months. Instead, we're here to talk about copyright law. Now, don't get me wrong, as Mr. Jordan said, there's a time and place to discuss copyright law, but the building is on fire, and we're talking about rearranging the furniture. The ship is sinking, and we're talking about what tune the band ought to play. But Mr. Chairman, you get to decide, what we're going to decide, what we're going to talk about. We're talking about copyright law, so I will ask some questions of Ms. Perlmutter. We do appreciate her being here today. Ms. Perlmutter, in addition to serving on this committee with oversight over the Copyright Office, I spent the last 6 years as the lead Republican on the House Small Business Committee. And in that role, I heard from countless small businesses and individuals across the country and in my congressional district who register creative works with your office, from books and music to software and photographs. Your office handles it all. But as you know, Congress, as you already mentioned, gave you a bit more responsibility late last year when we passed and the president signed into law the Copyright Alternative and Small Claims Enforcement Act, otherwise known as the CASE Act. I co-sponsored that and voted in favor of that because, in my view, it represented a way for copyright owners, particularly the smallest creators, to enforce their rights and receive compensation for their hard work when someone essentially copies it and or rips it off, and traditional litigation in federal court would be too costly to pursue. So, Ms. Perlmutter, let me ask you if you expect the Copyright Office to fully implement the CASE Act and have the Copyright Claims Board up and running by the end of this year?
Yes, thank you for that question. We are working very hard to make sure that we have everything in place for the Copyright Claims Board to start hearing cases by the end of the year. That involves work on hiring, it involves work on getting the regulations that are needed in place, and it involves developing the technology tools for the board. So we are optimistic that we will be able to do it. We have already in April received a number of applications for the claims officer positions, and I expect to provide a recommendation to the librarian for appointments to those positions in the coming weeks. We're working closely with the library's Office of the Chief Information Officer to identify the IT needs, which will include a case management system and the technology needed to conduct remote hearings, which is an important part of making the board as accessible and easy to use as possible.
Thank you. Let me stop you there if I can. We've got time to squeeze in one last question. And I assume that you agree that the registration of copyrights cannot be a one-size-fits-all process, and it should be take into account and protect the works of creators large and small, including those who probably can't afford the assistance of legal counsel. So I hope that you'll be taking that into consideration as well.
Absolutely. Thank you. We need to make this new system as totally inexpensive and usable and user-friendly as we possibly can. And that is our goal.
Thank you. I yield back, Mr. Chairman.
Gentleman yields back. Ms. Lofgren.
Thanks very much. And thanks to you, Mr. Chairman, and to the Register for being here today. There are a lot of important things that your office must do, but I think the number one priority, and they're all important, is to finish the modernization of the office. Because if we manage to do that and have that transparency, copyright holders will actually be empowered in a way that they've never had before, to have the protections that they seek in a way that is seamless and inexpensive. So I know you have very important obligations, implementing the CASE Act and the like. All of that I respect, but I want to hear from you that you will not allow anything to divert you from the goal of complete modernization of the office. Are we on track in that modernization?
We are on track, and it is absolutely a top priority. I couldn't agree with you more that this is critical to the future of the office and the future of our ability to serve the American public. So we are moving forward. We have had, as I mentioned, a number of major milestones just this past year. And as you know, and as the chairman mentioned, we are forming a public modernization committee to consult with on the IT issues. We are working closely with the library on all the IT modernization activities that include the project timelines and budget. And I do want to say that we are still aiming to meet our goal of retiring our legacy systems by the end of 2024 and replacing them with the new enterprise copyright system, which
That is
will be
that is
much
great.
more accessible to the public.
That is great. Now, I know there's been discussion of the DMCA. I think only 3 of us were on the committee when we drafted the DMCA, and obviously the technology was very different at the time. But certainly in a lot of ways, this has proven to be a huge success. For example, the Motion Picture Association reported global industry revenues of more than $100 billion for the first time ever in 2019. The music industry in 2019 reached over $11 billion for the 4th straight year in a row, double-digit growth, and it's powered by online services, video games, also through the roof. And the numbers, we don't have them yet, but during the pandemic, we're pretty sure even going to be higher. So from, there's concern about technology and protecting rights, but it's also a platform that has allowed for exponential growth for the distribution of creative content and the collection of funds for those creative contents. So we do want to make sure that the little guys don't get squashed. And I did support the CASE Act, although some in America were concerned that there was the potential for abuse or trolling on that system. I thought it was important to move forward to give an avenue for small, not the big studios, but the little guys to get access. How are you going to keep track to make sure that there is not abuse of this system, as there was at one time before a reform of the patent system with trolling?
Yes, thank you for that question. It's a very important issue. We are taking very seriously the importance of controlling abuse as the system goes into effect. So first of all, of course, the statute itself, and we thank you for that, includes a number of safeguards to protect against abuse. So for example, a claimant can't serve a respondent until the board approves the claim.
If I could, I understand the law, but I just want to know that you are paying attention to it so you can raise alarms to us if it goes off the rails. Hopefully that will not occur.
Yes, we absolutely are. And we recently, in the notice we recently issued asking for public comment, we asked people to talk about how do we make sure we avoid abuse, including looking at the conduct of attorneys and parties. So we will be very much on top of that.
I have time for one more question. There's Section 1201 rulemaking this year. And one of the issues, I actually helped draft that section, and we don't want to circumvent when we're protecting content, but we saw the growth of protection for non-content. For example, in the famous John Deere tractor case, where they slapped a piece of code so that the people who bought the trucks couldn't actually repair them themselves. That's a misuse of the circumvention provision because it's not protecting content, it's protecting a monopoly. I'm wondering, in the rulemaking, how are you going to address this issue?
Yeah, that is an important issue. And I know we've looked at issues having to do with using copyrighted software as a backdoor for other goals having to do with especially consumer products. We have a couple of exemptions that touch on those issues. We are recommending some legislative change as well. So stay tuned. We have just conducted 2 weeks of virtual hearings in the current rulemaking process and are looking at issues that relate to this topic, in addition to having recommended permanent exemptions to allow diagnosis, repair, and maintenance of computer programs, and allowing the librarian to adopt exemptions that allow third-party assistance. So I think all of those things may go toward your goal.
Thank you very much. My time has expired. I yield back, Mr. Chairman.
The gentlelady yields back. Mr. Gohmert.
Thank you, Mr. Chairman. appreciate you being here, Mr. Palmetto. Uh, it, having spent so much time on our southern border, it, we have got to do something to address that issue. That's wholly within our authority, and you know, there is so much suffering of those coming. We're continuing to pour billions of dollars to the drug cartels, and fentanyl, things that are killing Americans are coming in, sex trafficking at levels never seen. We really need to address that. That's nothing to say about the job you're doing, ma'am. I do have a number of questions. With regard to the Satellite Television Community Protection Promotion Act, um, are you seeing an effect that would restrict local news transmission? I hear a lot of complaints about that.
Well, we're in the process of developing a report on the effect of the recent amendments. We held hearings on this. We expect to issue the report by the deadline, and I'm checking what the deadline is exactly. And hopefully we will be addressing all of those issues.
So you don't even have an observation at this point?
Not at this point, but I would be happy to follow up with further response.
Well, that is rather critical to many of us. It should affect all of us. So I hope that we'll get those responses sooner rather than later. With regard to the resale royalty issue, I'm concerned about new quasi-government bureaucracies collecting the royalties on some art market participants, but not others. What is your observation to this point regarding some art market participants and not others?
I think the statute has to strike an appropriate balance, and that's one of the issues that we talked about in the report, and would be happy to give further advice on the exact lines that are drawn in the statute. But you're right, it has to be appropriate to the level of sophistication and commercial activities of the participants.
Well, it seems like the government is often the last to come along and utilize the most recent developments. And so I would hope that that would be more a role of a non-government entity when it comes to royalties. But and we've seen that with the music industry. They seem, if we just give them the tools, they seem quite capable of addressing the royalty issues even better than government or quasi-government bureaucracies.
Yes, and I know the statutes have considered the use of a collecting society as a way to handle that.
Yeah. And of course, with regard to the patent, I know we were told repeatedly that, oh, this bill will yet finally deal with the trolling issue, and it seemed to be a way to keep smashing and whacking all of the individual inventors. You mentioned whack-a-mole previously. It seems like we've been whacking our individual inventors to the benefit of the largest corporations. And I sure don't want to see that occur in the Copyright Office. What do you see and from your position that you can be doing to assure the propriety and the protection of individual copyright owners? I know you'd mentioned the problem of, gee, when you take some inappropriate material down, it gets put back up. What do you see can be done on those things?
Are you talking about, Congressman, the small claims court, or in general, the online online infringement, in general online infringement?
Right.
We need to make the system work so that not just big entities representing major commercial interests can use the notice and takedown system, but also individuals. So that's one of the concerns and one of the issues that led the Copyright Office in its report to recommend that Congress focus on clarifying the red flag standard for service providers to figure out a way to make sure that individuals weren't completely left to their own resources to locate each individual act of infringement. So I do think that's something that needs further attention.
Thank you. My time expired. Thank you, Mr. Chairman.
The gentleman's time is expired. The gentleman yields back, Ms. Jackson Lee.
Good morning. Thank you very much, Director Perlmutter. I appreciate your testimony. I noticed in your testimony that you stated one of the overarching goals of the U.S. Copyright Office is to further open up the copyright system involving more participants. We want the law and our services as easy to understand and as accessible as possible for individuals as well as businesses of all sizes. And this will include broadening our outreach and education efforts with a focus on underserved communities. Copyright, of course, is the engine of our economy, giving more people the opportunity to be innovative and exciting and create businesses and new ideas. How have certain communities been underserved by the current copyright system? And what communities are you focusing on to ensure that we have this kind of expanding? Can you expand on the current status, U.S. Copyright Office outreach and education efforts? And I do have other questions. Thank you.
Yes, and this is a very important priority and one that I'm very committed to. So there are a number of things the office has already been doing in this respect, and I want to expand further. So far, the office has focused very much on improving its outreach and doing a lot of promotional work to reach out to as many audiences as possible and make the copyright system as understandable as possible. So that should help in itself. Second, the office for a while now has been engaged in putting on events that focus on getting historically marginalized communities more involved in copyright discussions, including working with a group called Take Creative Control, which is an educational and advocacy group on social justice and IP. In connection with the MMA, in addition to outreach with a lot of different organizations representing under-resourced communities, we also are hiring, thanks to Congress's funding, one particular position that would focus on reaching those underserved communities. And then what I want to do going forward, which really goes to your first question, is to have our chief economist, once he or she is on board, really do a study of what groups are underrepresented in using copyright services and in using the courts to bring their claims. So I think we'll have a lot more information then. And the last thing I would mention is that we have just started participating with the National Commission on Expanding American Innovation, which the Patent and Trademark Office set up while I was there. I worked on it. And we are talking about expanding this focus on innovation to include creativity as well as technical innovation.
Well, I'd like to work with you on that and invite you as we proceed to be involved in communities across America. Let me quickly talk about Section 512 report, where you concluded that the Congress, when we intended to strike, when it enacted strike a balance, when it enacted the DMCA, has been tilted askew. That balance seems to have not been where we'd like it to be. And so rather than maybe a complete overhaul, the office highlights some areas that Congress can work on. I'd be interested in how you came to those conclusions. And then my last question is to deal with the different legislative approaches that foreign countries have taken to combat online infringement. And are there any international approaches that would translate well to the U.S. copyright system that Congress should look at? Conversely, are there approaches that we should not align ourselves with? Thank you.
Well, of course, I was not at the Copyright Office when the report was written, but having read it and discussed it with people, clearly the conclusions and the recommendations were based on the idea that the system as a whole has worked in many ways and should not be thrown out completely and reimagined. but rather there are ways that improvements can be made to deal with the problems that have been raised. The nature of those improvements that were recommended or at least highlighted as potential were very much based on the input that we received from all sides to try to identify those things where we could make the most difference or where Congress could make the most difference without leading to other problems. It's a complex statute that does the job of really setting a balance that is not easy to set. In terms of international approaches, it's interesting because the US approach in enacting the DMCA in 1998 has been hugely influential internationally, and countries around the world have based systems on it, perhaps with some tweaks, but primarily on it. What we've seen, particularly recently, is Europe, the European Union, moving ahead with new approaches and new sets of obligations in their digital single market directive. Member states are supposed to implement that by, I believe, June. It seems unlikely they all will. They're all following quite varying approaches to implementation, and US businesses are quite involved in looking at that and trying to decide how they will react to the different implementations that will take place around Europe. And some of those implementations may require changes in the nature of how service providers structure their services. So we will be watching with great interest and talking to stakeholders, including, of course, the service providers themselves, to see how that affects their views going forward and what they think might be done at all differently in the United States, whether through voluntary measures or through legislation.
Gentlelady's time has expired. Mr. Issa.
Thank you, Mr. Chairman. I think the two areas I want to concentrate on is the DMCA modernization potential and the Arts Act. And so starting with DMCA, I think we can all agree that before the digital age, when somebody simply ran a printing press on your work, and then you would find copies being printed, it was very possible that you wouldn't be able to find where they were printed or who was the person who had them or was selling them. But if you did, they could close their corporation, get a new printer and a new company, and go do the same thing again. So would you agree that, in a sense, we're dealing in a digital world with a model that is not really too different from what the bootleggers of music and books were doing in the 60s and before?
I would agree it's not different in that respect. I think the main difference is in sheer volume and geographic dispersion.
And in that sense, as we look to perhaps further modernize DMCA, would it be fair to say that the whack-a-mole problem, if you will, is a problem that artificial intelligence, in cooperation with the Copyright Office, would be able to allow through the notice and takedown, but then automating the second, third, fourth, and 1200th time that somebody moves, to be able to do them in milliseconds rather than in a longer period of time that allows for it to be profitable for the copyright violator?
Yes, I am optimistic that there are solutions that technology can find to this problem. And the question is how you do it in a way that is not too heavy-handed and doesn't sweep up things that shouldn't be swept up. What exactly are you preventing being reposted where? But I believe that stakeholders could come together and find ways forward using technology that's appropriately tailored.
Well, thank you, and I look forward to this committee and your offices being involved in that negotiation to hopefully a successful conclusion. Moving on to the proposed Art Act, I have just a couple of quick questions. As you understand the act, the first one is, we all understand that a sale is a contract between a willing buyer and willing seller. Today, is it fair to say that when you sell an art, a piece of art, a carpet, whatever it is, you have no expectation of a further revenue?
Yes.
And under this bill in its current form, wouldn't there be effectively up to 100 years of new revenue for existing works of art that have already been sold from a willing buyer to a willing seller at a price?
Yes, I'm not sure what the term is for the bill, but that is true. I think it's the goal is to allow visual artists to participate in future popularity of their work and enhanced popularity of their work in a way that they can't now, and that, for example, an author of a book can through the sale of further copies.
Well, and I agree with you, and we want to find a way to make this happen in our modernization. But the question is, although historically we've increased copyright lengths and that has been retroactive, it's more a term, not an actuality. Meaning, if somebody doesn't have a copyright obligation, they don't get one as a result of past legislation throughout the history of Congress. Term again might be extended, but not others. So if we were to enact it in its current form, isn't it in fact a retroactive taking, in that a willing buyer, willing seller very possibly would have a different price for passing on who gets that future royalty potential, because the future royalty can be sold by the artist along with the painting or other artwork. It can also be sold to a third party. So the question is, are we considering creating a right or a value that was not in the existing contract?
Yeah, that's an interesting question. That is one way of looking at it. I do think that a lot of the additional value that gets added over time is not something that anyone could have predicted. So it's a little bit difficult to say that it was foreseen at the time of the initial sale.
Well, but whoever holds the piece of art when it's sold, it will come out of the revenue they would receive. So the person who made the investment, the reason I'm asking, and I appreciate your indulgence, Chairman, is we want to get this bill right. And to me, the existing art is the biggest challenge to the change in the law. And Mr. Chairman, I thank you for your indulgence, and I yield back.
The gentleman yields back, Mr. Cohen.
Thank you, Mr. Chairman. First, Ms. Perlmutter, you've got an excellent resume, an excellent history, and I compliment you on your work for the Copyright Division. And the Music Modernization Act is certainly important to Tennessee, to Nashville, and to Memphis, with all the music that's been written here. But I do want to say that, Mr. Chairman, I agree with some of the things the Republicans have said earlier today. Mr. Jordan, Mr. Chabot, that they're right. There are issues of more importance than copyright, but we do need to look at copyright. And they're right that the House is on fire and it's our southern border. But it's not quite in our southern border, it's down in South Florida. What we saw yesterday in an opinion from Judge Amy Berman Jackson about the president's conduct that was hidden from us by the Attorney General, who lied to the Congress and lied to the American public about the Mueller report, is the House being on fire. And are our colleagues on the other side concerned about that? No, they're concerned about immigration. Immigration is important, and the Biden administration is working on it. But the previous Attorney General contemptuously avoided appearing before our committee. And then when he finally did, he arrogantly answered questions and he lied to us. And Judge Jackson has seen information that shows he lied to the American public when he released the Mueller report, or he released his synopsis, his summary of the Mueller report, 4 pages summarizing a 400-page report, and said that they could not indict the president, that Mueller said that. That was not true. Judge Jackson has ordered that that paper that was used to support his mendacity should be released to the public. Merrick Garland is an outstanding attorney general, I believe. He was a great judge. And I hope the chairman will write him, as I plan to, and urge him not to appeal this case and to let the American public and the spirit of transparency and democracy see what happened and what was done in justice to pervert justice, and to not allow the American people and Congress to know what went on with the Mueller report, why the President of the United States was not charged with obstruction of justice when there were 10 counts in the second section of the Mueller report, where Mr. Mueller said that appeared to be obstruction of justice, but it was up to Congress to decide, that we had the remedy, and to go into those issues and to see why the most unredacted Mueller report that does take into consideration and about sources and contacts as much as it can be unredacted, is released to our committee and possibly at some point later to the public, so the public knows what the Mueller report had in it. The American public needs to know about the illegalities, the lies, the contempt, the disregard for democracy, and the continuation of it. The southern border problem in Florida still goes on. On Monday, the former president said that the election was fraudulent, that it was not a legal election. And as Liz Cheney properly said, it's a continuing attack on democracy. The election was the most honest, the most thorough, the most investigated, the most reviewed by courts. I think 62 or 64 all said everything's fine, threw away all the Trump challenges and thrown away by Trump judges. And yet the former president is still trying to put out to the American public the idea that this was not a valid election of Joe Biden and make him out to be a president without papers. That's what Donald Trump might have been if we'd have seen the Mueller report and seen it. We now know that Klimnikov was given papers by Manafort, the campaign manager, given polling data that he took to Russian intelligence, direct connections. So, Mr. Chairman, I would ask you to look at Judge Jackson's statements, to look at what we've done with Don McCain refusing to testify before us, to pursue these issues, to get the truth out to the American public and to our committee, and to protect our Constitution, and to look into the lies and the misdeeds of the previous president. True, the Senate did not impeach him, which they should have 2 times. But the American public still needs the information. And it's possible, if they won't go along with the study of January 6th, the American public needs to know what went on there. Insurrectionists coming in and beating policemen, not just innocent Americans wanting to protest, not people just wanting to exercise their rights, who the president said go peacefully and politically. You wouldn't say go to the Capitol peacefully and politically if you knew they weren't going peacefully and politically. So maybe our committee should look into what went on January 6th, when our country had the biggest threat since the Civil War and the Capitol had its biggest offense and damage since the War of 1812. It's not anything to be forgotten. We take an oath. We as judiciary members need to see to it that the Constitution of the country is preserved and protected. Mr. Chairman, thank you for your work. God bless the United States of America, and let's put the fire out. I yield back the balance of my time.
I would simply point out that the committee is still pursuing Mr. McGahn, the subpoena that we issued, I think, almost 2 years ago. We're still pursuing that in court. The gentleman yields back, Mr. Massey.
Thank you, Mr. Chairman. Thank you for having a hearing on something where I think we could work across the aisle. I want to start at a high level, Mrs. Perlmutter, and then go down from there. I want to start with the directive that the founders gave us in the Constitution for establishing the office that you lead. It said in the Constitution, still does, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. I think it's wonderful that the founders saw fit to put that in there. I'm glad that you're a strong defender of intellectual property and copyrights. But I want to ask you about the length or the term of copyrights in relation to patents, for instance. So in the beginning of our country, 1790, the term for a copyright was 14 years and the term for a patent was 14 years. And now and you could get extensions, in one case 14 years, in another case 7 years. But now patents last for 20 years from the date of filing, and copyrights have grown to be the life of the author plus 70 years. In fact, there have been over 10 extensions since 1970. Can you talk about how we got to this period of time that's over a century, really, in most cases for copyrights, whereas patents are still at 20 years?
Yes, thank you for the question. It's difficult to compare copyrights and patents in terms of duration because the nature of the right is so different. A patent is the ability to exclude others entirely from using your invention for the period of time that the patent endures. For copyright, you are not allowing others to copy your expression. So the copyright does not prevent people still from using the ideas and facts in the work. And in fact, it doesn't even prevent them from using the exact same expression if they came up with it originally without copying from you. So for example, while that seems like it could be unlikely, you could have two people come up with the same melody for a popular song without having copied, or perhaps a design for a textile pattern. So the protection itself is much weaker than for patents. So I think it's difficult to compare them.
But the founders started, sorry to interrupt, the founders started them both out at 14 years apiece. And some would argue that patents have zero term now because the courts have eroded injunctive relief, which, the right to exclude. And so patents, I find it interesting. Now, hopefully we have a hearing on patents too. And I know you're head of the Copyright Office, not the Patent Office. But, patents are harder and harder to enforce these days. But how did we get to what is 70 years plus the life of the author? And how does that serve the constitutional directive to promote progress by securing for limited times?
Well, over the years, the thought was that copyrights should provide a livelihood to authors so that an author who wrote books for a living would be able to continue to create, and the author and his family would be able to be provided for. So there has been some discussion over the years of the copyright term approximating the term of someone's life and the life of their children. That's, I think, gradually how it got to that point. The most recent extension, which was in 1998, which was the only extension during the time that I've been working on copyright, was a deliberate decision by Congress to respond to an extension of copyright term in the European Union, where Europe was only going to give that extra 20 years to American works if we provided a similar term. So at the time, the Copyright Office, the then Register of Copyrights, testified that while there might or might not be strong arguments domestically for extending further, from an international perspective and a balance of competition and payments perspective, there were reasons to do it. So that's essentially how we got to where we are today.
Okay, and we've got 20 seconds left here, so I want to get in another question. My concern is that there will be a sneaky attempt by Congress to extend this beyond 70 years, like let's say another make it 90 years plus life of the author, which could end up being a century and a half, which I think does violate the constitutional directive. Can you tell us today that you will not advocate for an extension to extend that beyond the current period of time?
I have not heard anyone pushing for a further extension, and I would find it very surprising if that were to happen.
Okay, and you would not support it?
At this point, I can say I have no intention of supporting it.
Okay, thank you very much for answering the question. Most people don't do that when they come before us. I yield back.
Gentleman yields back, Mr. Johnson.
Mr.
Of
Chairman,
Georgia.
for holding today's hearing, and welcome Register Perlmutter. I join in congratulating you on your appointment to this very important position at this critical time, especially for creators as well as other stakeholders in the copyright ecosystem. As chair of the Intellectual Property Subcommittee, I'm particularly concerned with the runaway rise in online IP infringement. The office's report on Section 512 notice and takedown has prompted some important discussions about the future of online enforcement. One common theme that we have heard from stakeholders, and that the office also mentioned in its report, is that the level of cooperation between online service providers and rights holders that Congress envisioned has not come to fruition. Given how much technology has advanced in the last 2 decades, it's clear that a consensus-based approach to taking down is not viable for creators. Last fall, the office convened a series of discussions with stakeholders about standard technical measures. What insights did the office glean from those discussions? And what is the office's view on how Congress should be encouraging progress in developing these measures?
Thank you. I think that is a very important discussion. Part of the balance, as you suggest, in the original DMCA was the idea that online service providers would accommodate and not interfere with standard technical measures that could be used to protect copyrighted works. Those standard technology measures have never been developed, in fact, in the 20-some years since then. So our roundtables were intended to explore what such measures might exist, how they might be developed, and how they might be used. We did not hear a lot of, not to overuse the word consensus, we didn't hear a lot of consensus about how to achieve consensus, but I think there was general openness to the Copyright Office staying involved and assisting and continuing the conversations. I think it's a valuable route to continue. It may be that at some point Congress will need to look at how to define what is a standard technical measure for purpose.
All but two.
For purpose of the dialogue, because, for example, it may be that there won't be standard technical measures that will operate across all areas of copyright creativity, and there needs to be separate rules, or maybe it won't be possible to achieve 100% consensus. But we do think this is an important and fruitful area to continue work in, and we look forward to working with the committee.
Thank you. Recent reports such as the U.S. Trade Representative's 2020 review of notorious markets for counterfeiting and piracy show the devastation of unauthorized streaming of all sources of copyrighted content, both here and abroad. Do you believe that the current copyright laws are robust enough to effectively handle this increasing problem? And if not, what are some of the adjustments you would recommend Congress consider in restoring balance to the system?
Well, one very important step was the Protecting Lawful Streaming Act that was passed last year. This issue about having appropriate criminal penalties for unlawful streaming has been something that the Copyright Office has long advocated for. So that was clearly a step in the right direction. We're monitoring what's going on with streaming and other types of piracy, both in the United States and abroad, and working within the interagency to talk about what could be done going forward. And we hope to continue to work with Congress as you look at those issues.
Okay, thank you. And I also support your efforts to bring on a chief economist and have seen through the USPTO what great value those positions can bring. What will be the chief economist's primary initial priorities, and how will the chief economist function be supported?
The initial priority will really be to develop an appropriate research agenda. I think there are a plethora of issues that would be extremely valuable to have analyzed. One of them will surely be looking at the question about the representation of women and minorities in the copyright system. That's a role that the chief economist at the PTO has played very importantly. In terms of support, we of course are going to start relatively small. We're going to hire just a chief economist and have them be supported by the existing staff at the office. But we also anticipate that the Copyright Office chief economist will be able to work closely with the chief economist at the PTO, whose remit also includes copyright policy issues, and that they can be force multipliers for each other in the initial stages. And then as things move on, we will see what additional support might be needed.
Thank you, and I yield back.
The gentleman yields back. Mr. Gates.
Thank you, Mr. Chairman. And I want to follow up on a thread of questioning from Congresswoman Jackson Lee regarding foreign entities and foreign interests. Director Perlmutter, could you comment on the role of any foreign entities and really the extent to which the Copyright Office has to focus on that versus any type of domestic infringement?
Well, as you suggest, Congressman, a lot of the infringement that copyright owners face these days comes from abroad, and that is clearly a major issue. Uh, for that reason, one of the things we spend a lot of time on is working with the U.S. Trade Representative, including in their notorious market report and their special 301 report, to identify and call out those sources of tremendous foreign infringement. And then the administration takes various types of action to try to address those sources.
And are there additional tools that you think the Copyright Office could have to combat that foreign malign influence?
That's a good question. We, of course, don't actually have enforcement powers ourselves, but we do advise on enforcement issues, on policy and on drafting. And we do work with counterparts in other countries to try to improve their laws to allow them to address some of these issues on their own territory.
And so it seems that your job is to inform the U.S. Trade Representative and other entities within the government where this action occurs, and then they really have the hammer. You provide the data and the information, but they have the hammer. And so could you provide us the information? Where in the world do we see this foreign malign influence coming from, principally?
Well, I would refer you primarily to the Special 301 report that USTR just released, which identifies very clearly where the main areas of concern are and actually ranks them in terms of the level of danger.
And do you worry that there are any increasing trends, particularly from China, to violate U.S. copyright laws?
The issue of infringement and infringing product coming into the United States, certainly China is a major player. I think it is something that the government as a whole continues to keep a very close eye on, and that includes, of course, looking at how and to what extent China is implementing phase one of the trade agreement struck with the United States in the last administration.
Thank you very much, Mr. Chairman. I yield back.
Gentleman yields back. Mr. Deutsch.
Thank you, Mr. Chairman. Welcome, Register Perlmutter. It's a pleasure to hear from you today and to work with you in your role as Registrar. I'd like to start with a report that predates your time at the Copyright Office, but it's an issue that I'm sure you know well. In 2015, the U.S. Copyright Office released a report entitled Copyright in the Music Marketplace. The office identified shortcomings of the existing music marketplace and made recommendations for policy fixes. One of the recommendations was the creation of a full sound recording performance right, which would include terrestrial radio. The report highlights the lack of a performance right as inequitable to rights holders and curtails the reciprocal flow of such royalties into the United States. It also pointed out what seems obvious to so many of us, that the failure to require terrestrial radio to pay performers for their works, while internet and satellite radio do pay performers, the report, to quote the report, harms competing satellite and internet radio providers. And the report went so far as to say that the market distorting impact of the terrestrial radio exemption probably cannot be overstated. Is this still the position of the Copyright Office, Register Perlmutter?
It is absolutely still the position of the Copyright Office. It has been actually the position of the office for a very long time. And immediately after I joined the office, I actually co-signed a letter with Andre Iancu, who was at that time the director of the U.S. Patent and Trademark Office, urging that Congress extend the public performance right for broadcasters to sound recordings.
And the report, that 2015 report, discusses the negative impact that the lack of the terrestrial performance right has on international royalties for U.S. performers. Can you just explain that to the committee, please?
Yes, under international law, countries are not required to extend protection to performers and record producers from other countries if their laws don't provide a similar protection. It's called reciprocity. And in what is happening is that because American sound recordings are so popular in other countries, a lot of money is being collected for their broadcast abroad, but there is no obligation under this principle of reciprocity for the money to actually be paid out to Americans. And so we are losing, I don't have the exact figures at my fingertips, but we are losing a tremendous amount of money each year from the enjoyment of American music in other countries.
I appreciate that explanation. This committee has a strong and bipartisan record of supporting performance rights. The chairman has been a leader on this issue, a leading voice on this issue for years, and I look forward to working with my colleagues to finally establish a performance right across all radio platforms. From a basic fairness perspective, it's well past time to respect the rights of U.S. performers and ensure that terrestrial radio plays by the same rules as internet and satellite radio. And I thank you very much for your insight, Registrar Perlmutter. I also want to follow up on Mr. Johnson's question on Section 512 of the Digital Millennium Copyright Act and the standard technical measures that were intended to be used by a broad consensus of stakeholders. As you point out, that consensus was never reached. It could be a powerful element of the notice and takedown system. It would make it work more effectively. It would give both creators and online service providers a set of common tools and standards. And this seems like a small and obscure change, but if those measures were in place, rights holders would benefit from these simpler tools. You pointed out there's no consensus at this point. You're open to continuing the conversation. You also talked about perhaps having separate rules for different kinds of technology. Can you expand on that a little bit? How would that look?
What I was referring to is not so much different rules for different type of technology as different technologies that would work in different sectors. So perhaps different technologies for motion pictures than for music or books or software. It seems as though one size fits all might not be the most effective way to move forward, both in terms of how the actual negotiation process of the development would work and who was at the table, but also in terms of what the technical measures would look like.
Great. Well, Registrar Perlmutter, we appreciate your being here. I look forward to working with you on these issues and so many others. Grateful for your service. And Mr. Chairman, I yield back.
Gentleman yields back. Mr. Johnson of Louisiana.
Thank you, Mr. Chairman. I have to start off by echoing what many of my colleagues have already pointed out today, that this is the first hearing of the full Judiciary Committee in nearly 5 months. And it really is outrageous that we're not focusing on the growing humanitarian crisis at our southern border and the policies of the Biden administration that are causing that dangerous surge. This committee has a duty, as has been said, to address this crisis. We're derelict in that duty by not doing it. And instead today, we're talking about how we can fine-tune copyright law. I'm not saying copyright law is not important, but it's not an excuse to ignore the border. But here we are. So let's address the issue. As many on this committee are aware, we're locked in a struggle with China right now to remain the preeminent global economic superpower. And one of the great strengths that's allowed our nation to defeat the Soviet Union and to maintain our status on the globe is our American ingenuity and our ability to spread American ideas throughout the world. Today, America remains the ideas factory of the world. And thanks to a legal ecosystem for protecting IP that enables us to be the global destination for commerce. In the last Congress, I chaired the Republican Study Committee. It's the largest caucus of Republicans on the Hill. And we published a lengthy task force report detailing how to effectively deter China's attempts to surpass us economically. And a lot of that focus was on critical items centered around continuing to build legal frameworks capable of protecting the intellectual property of Americans. And we have to do that if we're going to maintain our status and be the hub of ingenuity as we've always been. The Copyright Office's effectiveness plays a big role in that, of course, protecting America's status in that way. And laws such as the Music Modernization Act take similar steps to achieve that much larger end. So with that, Director Perlmutter, I just wanted to ask you about the status of the Music Licensing Collective, that database in terms of its completeness to date, its accuracy, accessibility, usability. What would you say about that?
Well, we're still at early days. Of course, the new license only went into effect on January 1st. The MLC has started to operate and to administer the blanket license and just made its first distribution just a few weeks ago. We are monitoring the progress. We are looking at how the system is going to operate. Of course, in 5 years, we will be called upon to make a decision again about whether to redesignate the MLC. So there's that ongoing review process, and we're open to receiving comments from users of the system all along. And we've established a few regulations regarding what the MLC has to disclose and make available in its reports. So it's still an ongoing process, but agree with you completely that it's critical that that database be as accurate and reliable as possible. And that is the goal of the legislation, of course.
Well, I'm glad to hear that you're engaging directly with the MLC. And we did have one question about that database. It's currently limited to information about mechanical rights, as you know. So some of the discussion has been, should we or could we improve the database to include information about performing rights organizations as well? And then the next question is, does the MMA, the act itself, provide sufficient authority to do that? Do you have thoughts on that issue?
Yeah, that's a good question. It's my understanding that there have been some discussions along that line, but I don't think it's happened. And I'd be happy to get back to you with more information.
Well, that'd be great, because I think we all agree it's an important tool, and we do want to fine tune that and make it as useful and effective as possible. So we'd appreciate your input on that. And Mr. Chairman, with that, I'll yield back the remainder of my time.
Gentleman yields back. Ms. Jayapal.
Thank you, Mr. Chairman. Director Perlmutter, thank you so much for being with us. Your office is very, very important in my 7th District of Washington, home to the rich history of the Seattle music scene and musicians like Jimi Hendrix, Ernestine Anderson, Nirvana, Bing Crosby, Sir Mix-a-Lot, Pearl Jam, Brandi Carlile, Shabazz Palaces, and so many more, as well as nearly 17,000 people directly employed by the music industry, most of whom earn their money playing gigs, teaching music, and recording music. The Copyright Office's report on Section 512 affirmed what musicians and songwriters have known for years, which is that the current system has been failing music creators and those of us that love music and the musicians in our communities. Now, because of the pandemic, these creators are even more reliant than ever on online revenue streams. Can you speak to what the Copyright Office has done to respond to the needs of creators during the pandemic?
Yes, it's been an interesting time, and we've spent a lot of time making sure that we are being as responsive as we possibly can. So we've certainly, among other things, used the flexibilities given to us in the CARES Act to give relief for certain deadlines where people might have difficulty pulling together the material they needed. We've used the flexibilities to modify procedural requirements so that they can deposit electronic copies rather than physical copies during the pandemic. There have been a number of, and we keep looking at ways that we might need to adjust as we get information from people. And I've been extending the flexibilities and will continue to do so until such time as it's clear they're no longer needed. So we're certainly trying to do things to help.
I really appreciate that. And I wanted to pick up on something that Representative Deutsch was starting to focus on. And that is, you know, some of these small independent artists, like the musicians in my district, they really do face very different challenges than what a large copyright owner like Universal Music Group or Sony Music faces. They lack the resources, these smaller independent songwriters lack the resources to track infringements on the internet because it's so big. Even when a takedown notice is sent, the material can pop right back up again on the very same platform, with the burden on the musicians to track themselves. And in the 2 decades since Congress passed the DMCA, large companies like YouTube have developed their own infringement detection tools that they make available to larger companies, but not always or consistently to independent musicians or other small creators. What is your office doing to help ensure that these small creators have access to some of the voluntary tools that larger creators have access to on YouTube or other large platforms?
Yes, that's a good question and a real concern. We certainly, I mean, one of the things we are doing on a regular basis on all issues is trying to reach out and provide good educational materials and be available to answer questions. But absolutely, one of the tensions is that it is technology that will enable a lot better use of the system from everyone's perspective, including for small creators who find it difficult to scour the entire internet on a regular basis. And yet at the same time, to the extent that that technology is developed, it may not be easily within the reach of smaller users. In fact, whether they're copyright owners or small service providers for that matter. So this is definitely an issue that we need to look at and we need to think about. Our report did make the point that one size fits all just doesn't work in today's system. And while I don't think we yet have all the answers, we are very focused on this problem and will continue to be so.
Well, I hope you'll keep our office informed on that because it's just something that keeps coming up over and over again, and we need to address it as quickly as possible. Of the suggested changes to the law in the Office's Section 512 report, which ones would do the most to help create parity among all content creators, including small creators?
I think one of the main recommendations, which is to clarify what the red flag knowledge standards means and how it relates to actual knowledge, would be extremely helpful. We also focused on the fact that there's no standard requirement for how to notify a service provider, and there may be some extra burdens being placed on individuals in terms of what providers require in the form of notice. We are concerned about that. We do think maybe having more of a standardized form could be useful. And on our website now, we do have model forms for notice and counter notice, and we think it could be useful for people to use those. So I think those are among the things that could really help.
Well, I really appreciate this. It's so easy to get lost in the technology and the bureaucracy of copyright discussions, but really this is about making sure that creatives are justly compensated for their work. Thank you so much, Director Perlmutter. Mr. Chairman, I yield back.
Gentlelady yields back. Mr. Stubbe.
Thank you, Mr. Chairman. First, I'd like to join my colleagues in expressing disappointment that several months into this Congress, this is the first time that the full committee is holding a hearing on copyright. While today's topic is important, so is the crisis at the border, attacks on the Second Amendment, court packing, and countless other issues coming from the Biden administration. So I hope to see the committee hold an oversight hearing with actual officials from the Biden administration to discuss these pressing issues facing our country. Ma'am, thank you for being here today and for your service to the Copyright Office. I have a question related to your position in general. The Register of Copyrights is appointed by the Librarian of Congress and not the President. And the Librarian of Congress, while appointed by a president, serves a 10-year term that crosses over administrations. So this means that your position is very insulated from political pressure and from voters. Given the important functions of your office, is this level of insulation appropriate? And besides occasional hearings such as this, how is your office held accountable?
I've followed and am aware of the discussions of this issue over the past years and some of the bills that have been introduced. My view is that there are both pros and cons with the idea of making a change and having this position be a presidentially appointed position. In my experience, certainly in 6 months on the job, it is working well as it is. I do think that we have a librarian who's presidentially appointed, who I report to. We work very closely with the Hill, with this committee, and also with the Senate, of course. And we work closely with other agencies in the executive branch that are focused on IP policy issues. We report regularly, including an annual report to Congress. I believe there are plenty of opportunities to make sure that there's adequate oversight, but to the extent that there was a perception of a problem, of course, that is always something to discuss. It has to be borne in mind that any change will come with both positives and negatives that would need to be thoroughly considered.
It's my understanding that very few make use of the counter notice provisions of Section 512 of the Digital Millennium Copyright Act. What do you believe is the main reason for that, and what do you believe should be done about it?
I would have to be speculating about the main reason. It is possible that most of the notices that are received do not involve any mistake or misidentification, but are just very blatant cases of infringement. And so there's no need for a counter notice. but there's also a possibility that those whose content is taken down may not be aware of the full rights that they have to use the counter notice process. And then, as our 512 report pointed out, there's also some concern that the time period set out for the counter notification process may be both too long and too short. Perhaps too long in terms of how long one has to wait to get content reposted, and too short in terms of the fact that the right holder is required to take steps to initiate a federal litigation to counter the counter notice. We would like to make sure that people know how to use their ability to submit a counter notice. And again, on our website, we now have model forms for that, which we hope will help, as well as a lot of information.
Okay, on the topic of the DMCA, should there be different ways to handle different types of content, such as live streaming of sports or other such events? And if so, how would that be accomplished?
At present, in the DMCA, there has not been an attempt to specify, at least through statute, different routes and different methods for different types of works. I am not aware of any areas where that would be necessary, but if it were, then I certainly think we should be looking at that.
The Music Licensing Collective was created by the Music Modernization Act and was in some ways the focus of that legislation. How's your office making sure that the MLC exercises fiscal responsibility with respect to the royalties it collects and distributes, both matched and unclaimed?
We don't have general oversight into all of the activities of the MLC, but we are responsible for designating and redesignating, and that process will include ensuring that the entity is doing a good job at what it's supposed to be doing. So we are accepting comments, and we will be looking at that, as well as, of course, our work in generally setting out regulations governing how it operates and how it reports.
Well, thank you for being here today. My time's expired.
Gentleman yields back. Ms. Demings.
Thank you so much, Mr. Chairman, and thank you, Ms. Perlmutter, for being with us today. I know a couple of my colleagues have addressed this issue, but I'm not sure, I may have missed it. Some of the questions dealt with the approaches that we are taking to address foreign online infringement, but I would like to know if there are any international approaches that translate well. And I know Ms. Jackson asked a similar question, and I know we're monitoring, but have you identified any international approaches that translates well to the US copyright system?
Well, we are constantly looking at that. I think it is extremely important to always be aware that other countries may come up with ideas that we can adapt here if we find them useful, just as much, well, in addition to our work in advocating for the US policy positions outside the country. I think there's a lot of work being done now, which is somewhat unproven in terms of how well it's going to work. So we're still in a watch and see mode when it comes to things like the European Union's Article 17, which some have interpreted to require filtering or notice and stay down. So we want to see what it means, how it can be accommodated from a technological perspective, and what the impact will be before we would be ready to say that we would recommend any part of it here.
So we have not seen anything coming out of the European Union that we are quite ready to adopt.
It's still early days. They're still in the process of implementation.
Thank you so much. I know that COVID-19 has hit us all hard. We've all had to make some adjustments. Can you elaborate on the measures your office implemented to continue operating and serving the public virtually over the past year?
Yes, we've done a number of things. Certainly internally, we've moved to telework, and we've tried to adjust our processes because some of our processes deal with physical materials, whether it's physical deposits or certificates of registration or mail. There are certain things that we have suffered from not having people on site to be able to handle. In terms of the public, we've put in place a number of flexibilities, either through authorities that we already had or under the CARES Act. And that's included finding ways for people to submit payments that in the past they did through checks and money orders to be able to do it electronically, ways to be able to not have to submit best editions in physical form in order to get a filing date and to start the clock running on their copyright registration.
You also extended some of the deadlines, is that correct?
And we extended deadlines, and we're continuing to do so. I'm extending all the flexibilities, or most of the flexibilities, as they are still needed.
Do you believe Congress should be considering a permanent version of these emergency powers for future emergencies?
I think it could be useful, yes.
Thank you. And finally, what new legal or policy issues does the office foresee becoming important over the next few years?
I think the overall issue of the roles and responsibilities of internet intermediaries is going to continue to percolate. And obviously that's true not just in the copyright area. There's also a lot of discussion about artificial intelligence and the related issue of text and data mining. And then we keep looking at the existing specific exceptions and limitations in the Copyright Act, and some of them we believe need updating. And then, of course, fair use and how it's applied by the court keeps evolving, by the courts keeps evolving, most notably with the recent Supreme Court decision in Google v. Oracle. So I think those are some of the highlights that I would mention.
Okay, great. Thank you so much, Mr. Chairman. I yield back.
Gentlelady yields back. Mr. Bishop.
Thank you, Mr. Chairman. I appreciate the comments of a number of members who've come before about how the priority has been set for this hearing amid the many issues that we have to, that are pressing. In particular, maybe the irrepressible gentleman from Tennessee, who certainly couldn't resist taking the bait for understandable reasons. But and many of the questions, Ms. Perlmutter, you've already been asked, covering the issues of refinement of the Copyright Office operations. That's already been done, I think, well. I thought I'd just offer one other perspective on the issue of the priority setting by the majority here. There are 12 members of this committee who have not been members in the 116th Congress, or were not initially. 29% of the membership of this committee. And here is a list that I can think of as I sat here of major pieces of legislation within the Jurisdictions Committee that have run on the floor this year without ever having a committee hearing to address them. HR 1, the bill to federalize all election regulation and ban voter ID, the 2 immigration mass amnesty bills, the bill for DC statehood, the PRO Act, which would nullify right to work laws in 20-something states and substantially destroy the independent contractor model. The bill to essentially defund or cripple police forces, masquerading as a police reform bill. The so-called Paycheck Fairness Act, having government scrutinize pay practices of employers all over the country. The Violence Against Women Act extension or reauthorization to cover transgender ideology, the ERA deadline extension, the crime victims funding amendments. I'm probably leaving out some big ones. Even the impeachment matter at the beginning of session and the urging of the House of the Democrat majority for the Vice President to exercise power under the 25th Amendment. None of that came before this committee. None of it afforded an opportunity for the 12 new members to participate in the committee process that would be normal. And I agree with the gentleman from Tennessee and others that there are other issues that is inconceivable have been subordinated to this hearing. We have preliminary data. We'll see more data from the Customs and Border Patrol within the next several days, but it appears that following the 174,000 apprehensions of illegals at the border last month, we're going to be at or slightly above that level for another month, having no precedent within the past 20 years. We see there are issues concerning irregularities in the election that occurred that have not been examined by this committee. The fact that there were 400 lawsuits approximately filed to attack basic elections regulation by Democrat by the Democrat National Committee in the hands of Mark Elias, that there was big tech suppression of information like the Hunter Biden laptop in advance of the election. We haven't even had a hearing to address the court packing scheme Democrats have rolled out. It's just astonishing that the priorities that are set here by the majority are, in terms of the hearing time of this committee, are a reflection on the regard that the majority has for the functioning of this committee and its role in this Congress. The American people should take note, and I yield back.
The gentleman yields back. Ms. Scanlon.
Thank you, Chairman Nadler. The issue of copyright infringement and enforcement is a big one in my district. I regularly meet with our artists and small businesses who struggle to effectively use the notice and takedown system to enforce their copyrights online. The system is arranged in a way that makes accuracy and efficiency difficult for our smaller creators who often have trouble enforcing their intellectual property online. So while larger content creators have some solutions and resources with which they can navigate the notice and takedown system, the solutions offered to smaller creators are burdensome and prone to error, and it's resulted in a system that really isn't fair. We need to create a system that works for even the smallest of solo content creators, one that doesn't sacrifice the variety of internet content while also protecting rights holders. So, Ms. Perlmutter, we had a hearing in September, and I spoke then about the burden on small businesses and solo content creators in navigating notice and takedown process. As it stands right now, I'm hearing that the process doesn't seem to be working for creators who lack large financial resources or access to automatic infringement detection tools. And I understand that the Copyright Office's May 2020 5-year study on Section 512 found similar discontent among individual rights holders navigating this office. Now, I wanted to dig a little into the knowledge part of Section 512. So Section 512 contemplates that if a service provider has actual knowledge or red flag knowledge of an infringement, then its obligation to take that material down is triggered. But we've seen in application, the balance is tipped away from the needs of the creative community and in favor of the large internet platforms. We know, for instance, that the creative community sent over 900 million takedown notices each year to Google and YouTube alone. The Copyright Office found that one of the issues we're contending with here is that the courts have blurred the lines between actual knowledge and red flag knowledge. So I understand from the report that the office believes that maybe Congress could pay some attention to clarifying the distinction between actual and red flag knowledge. Can you discuss that a little bit?
Yes, I wanted to start by saying I completely agree that the system has to work for individuals as well as for large companies, and that was always intended, and that's one of our goals. I was at the Copyright Office and involved in crafting the language on red flag knowledge in the DMCA, and I know the intent at the time was something that was less than constructive knowledge, but more than actual. So the idea was there was both a objective and a subjective element. So there had to be actual awareness, but only of facts and circumstances from which infringement was apparent. And the intent was not for it to be every individual act of infringement had to be specified and specified in a notice. So I think this is an area where the courts have interpreted the law in a way that is different from what was originally intended, and some clarification would be useful.
I was also interested in the report finding that the application of the willful blindness standard is also problematic in this space. And we certainly know that these big tech platforms have developed algorithms which enable them to do an awful lot of things. And so putting their widespread use of algorithms to make profit, next to the fact that they seem willfully blind to the fact that there's all this copyright infringement going on, sometimes even in their favor. That seems like an area that should be ripe for congressional action.
Yes, and there needs to be a balance. It's a difficult area because clearly the statute says there should be no requirement of monitoring. And so you want to avoid a general monitoring obligation, but also not countenance the deliberate turning of a blind eye.
Do you think we should move to some kind of monitoring? Because we certainly see with the big platforms, and maybe it's just with respect to those OSPs or whatever, that they're monitoring everything else we do. Could it be fair to impose some level of monitoring duty?
I think there's a way to achieve our goals without requiring general overall monitoring, which could be quite prohibitive.
Right, and I understand that there's dangers in going too far that way as well, which we're combating in other sectors as well. I think my time has expired. Thank you very much.
Gentlelady yields back. Ms. Sparks.
Thank you, Mr. Chairman. Thank you for the testimony. I kind of wanted to really echo my colleagues and mention that, we had some discussion on immigration and immigration subcommittee, but this committee need to have discussion on border security. It's a very important issue, and hopefully we can come together and do it. I also want to thank you for really talking about this issue, and also wanted to kind of echo some of the concern with big tech and Section 512 issues. And I would like to ask you to work with with Congress, and just to see how we can really address it in an effective way. I think President Obama, when he made that an office to limit it to 10 years, he wanted to make sure that we can have this issue addressed and changes in technology being addressed by the office more effectively. And I think that was a good way to do that. But I have a question for you about something that President Biden, in his address to Congress last week, he said that he will continue to stand up to unfair trade practices that undercut American workers and American industries, like subsidies to state-owned enterprises and the theft of American technology intellectual property. Intellectual property is very important issues. Have you met with the president and really have a plan what you're planning to do to implement some of these policies?
I have not met personally with the president, but we work very closely within the interagency group that works on all of these issues, including with the IP enforcement coordinator once that position is filled again. So we are quite cognizant of how critical these issues are. I think in the government, everyone is very much in the same place on the importance of controlling the infringement of American products abroad, the piracy and counterfeiting side of the equation.
Do you believe you have a plan that you would be able to give periodic updates on the results and kind of where on the progress of this, what you're going to be working on? Because it's a big issue and it's built in president's address. I want to make sure that, because we talk a lot, but make sure that we have policies. So is that something you already have a plan and some of the key steps that you would be able to share, or you're still working with an office?
Yes, there are plans and steps in process. We don't have the lead on this. It is more a matter for the U.S. Trade Representative, but we are certainly involved and happy to answer any questions at any time.
Right, and so you would be able to, next time we talk, you will be able to update on some of the progress and accomplishments and results of that plan. Would you be able to do it for us?
Yes, happy to give a report to supplement and add to anything that the U.S. Trade Representative is reporting.
Okay, well, I would like for us to work very closely with Congress and with the executive branch as we actually done, because this is a big issue and it's really affect a lot of companies in our country and a lot of constituents in our district. And we need to make sure that we have policies and not just talking points, but actual results and plans how we're going to implement. So thank you for being here, and I yield back.
Gentlelady yields back. Ms. McBath.
Thank you so much, Chairman. And thank you so very much, Director Perlmutter, for being with us this morning. We really appreciate your testimony. And I'm glad that we've actually had this opportunity to discuss how we can continue to promote the arts and make sure that we're really thinking very carefully about how we protect the rights of our musicians and our writers, our visual artists, and other creators. And this is no easy feat in our modern technological era, in which we must also be really thoughtful about how information, music, art, and our very culture is shared. And something that I don't think was really kind of touched upon today, and I've been also trying to be on another hearing as well, but like I would like to talk a little bit about what's been happening under COVID. Like many of our workplaces, you know, the Copyright Office had to adapt to the COVID-19 pandemic, including the need for telework, which now, of course, all of us have been teleworking, and then also the use of temporary extensions of deadlines and allowing for more electronic submissions. So what has the office learned from these adaptations? And for example, could more processes be moved to electronic submissions?
That's an excellent question, and one that I'm spending a lot of time thinking about. I think some of our processes, we will be able to take advantage of what we learned and move to more electronic submissions. And in some ways, the experience in this year of the pandemic has enabled us to speed up what was already in process and what was already planned in that respect. So I think that will all be to the good. So the question is just, in those areas where we can't do things fully electronically, how we make it more efficient and more effective. And then a lot of our processes that were paper-based in the past, we're really quite rapidly moving to electronic systems, like in particular the recordation system, which was purely, almost entirely paper-based until now. So there's a lot of new developments. And in terms of the workforce, we've been able to be quite productive teleworking. We now have about a quarter of our staff coming on site at least part-time because of the physical needs of the job. But I am sure we are going to end up doing more telework and relying more on those abilities, both in terms of day-to-day work and in terms of events and outreach and programming than we have done in the past.
So thank you for that. And the Music Modernization Act directed the Copyright Office in consultation with the Government Accountability Office to conduct a study to recommend the best practices for the mechanical licensing collective to implement for identifying and locating copyright owners that have unclaimed royalties, for encouraging copyright owners to claim the royalties and for reducing the incidence of unclaimed royalties. And I've spoken to many, I live here in Georgia, so I've spoken to many individuals that have kind of posed that same problem to me. When will this study be completed? And what have you learned so far about how we can make sure that royalties get to the musicians who've actually worked really hard to earn them?
It's a very important study, and we've heard a lot of ideas from a lot of different sources. We have held hearings and roundtables and gathered a lot of information in written form as well. And we are fully on track to complete the study by the deadline, which is July 8th. So we're talking about only, if I can calculate correctly, 2 months from now.
Okay, well, thank you so much. I appreciate your time, and I yield back the balance of my time.
Gentlelady yields back. Mr. Fitzgerald. It looks like Mr. Fitzgerald stepped away, so we'll go to Mr. Owens.
First of all, thank you for this hearing. I found it very informative. I have no questions at this time, and I yield back my time. Thank you very much.
Mr. Stanton.
Thank you very much, Mr. Chairman, for holding this important hearing. Can you hear me okay? Excellent.
Yes, we can.
All right, and thank you, Director Perlmutter, for the outstanding information. I wanted to direct my questions to issues as it relates to the CASE Act and making the Copyright Office more accessible to small and medium-sized copyright owners. You may have addressed a little bit earlier I do want to reiterate the December 27th, 2021 date for getting the copyright up and running. How's that going?
It's going well. It's a short deadline for getting a lot of work done, but we are operating on firing on all cylinders at the moment. So we're working on the regulatory side. We've issued a notice asking for comment on how the regulation should be drafted and what issues they should address. And then we will be issuing draft regulations based on those comments for further comment. We are deep into the hiring process for the 3 judges, and we are engaged in developing the technology that they will need for case management and for conducting remote hearings. So things are moving along. Our hope and our plan is to have it done by the end of December. I know the statute gives me a little bit of flexibility if needed, but we are certainly hoping not to need that flexibility.
That's great. Well, we are excited to get that board up and running as soon as possible to make the system as accessible as possible for less sophisticated actors, those not represented by counsel. Maybe you can go a little more detail. How do you plan to make the Copyright Claims Board accessible to members of the public who are not as sophisticated in copyright law and not represented by counsel?
Yeah, that's a very equally important to all the work setting it up is the work in making sure that people know about it and know how to use it or choose not to use it. So we have already set up a website, a dedicated website with information about the CCB and Q&A, and we'll be updating that as the regulations start to take form and the processes and structure start to take form. We're doing a lot of outreach with different groups and organizations, and we're making sure that it is as all of these processes are as understandable and clear and usable as they possibly can be. And that includes both for people who have claims they want to bring, people who have who maybe want a declaration of non-infringement before they start some sort of activity, and for people who have claims about misrepresentations under the DMCA notice and takedown system. And we also need to make sure that people know not only that they can bring claims, but for respondents that they know what the costs and benefits are of deciding to opt out and how they can do it.
One of the innovative things about the CASE Act was the provisions allowing for representation by law students, not members of the bar, prepared to be members of the bar. I think that's a great advancement, and it'll help some of the claimants, and it helped the law students themselves as they prepare for legal careers in this important area. How is the office planning to work with law schools to help begin this process, to help begin the facilitation of law student representation?
We have a lot of good connections with law schools around the country. We partner with them on a lot of different issues. So I'm sure we're going to be using those connections. And of course, the more people we can get who can help, those who want to use the CCB, the better. So this will be also a focus of attention.
Okay, we really appreciate that. You know, when I was a law student, I had a chance to work at the Child Advocacy Law Clinic and represent children, termination of parental rights here. It was great training for a legal career. So I'm excited that that was included in the CASE Act. And so we are really looking forward to working closely with you to get that claim board up and running, and anything you need from us here in Congress to make the claims board successful, please let us know. And that, Mr. Chairman, I yield back.
Ms. Dean, I think you're on mute.
I'm sorry, I didn't hear. Thank you, Mr. Chairman, and thank you, Register Perlmutter, for being with us today. I wanted to follow up relatively quickly on your 3 priorities, which I champion along with you. The continuation, as Representative Loughran said, of modernization, that it can't be a once and done, that it has to be continuously updated. And I just wonder, from your experience, you said that 98% of your staff went to full or partial virtual. At the same time, you're trying to affect modernization. How was that path? What bumps and obstacles were in the way, particularly for those seeking copyright protection?
I think it's been, as I said, a challenging year because people are doing their regular full-time jobs and adapting to doing them remotely at the same time as they're also working on the modernization initiative because we need subject matter experts to work with the IT experts all along the way. But things are moving along well. People have adapted and adjusted well. We have not seen a decline in registration and the use of our services. People have been using the flexibilities that we've put into place. And so I'm tremendously gratified to see, in fact, how smoothly things have gone from the perspective both internally in the office and from what we're hearing from stakeholders.
Do you have any guess as to how much you might retain virtual employees?
Well, of course, we work within the library, which has centralized responsibility for HR. They are currently in the process of determining what the library-wide policy will be for remote work, but it will undoubtedly give a fair amount of flexibility to the Copyright Office and the other service units within the library to determine what makes sense for us. And what I have been saying to staff is that I am sure we will have more flexibility for telework than we've had in the past, although probably not quite as much as we've had during the pandemic. We're trying to figure out the right balance to give people flexibility, but also not to lose some of the benefits from in-person interactions that we've missed during the past year.
Yeah, we all have missed those. Adding to the conversation, I too think it's fantastic that you will be hiring a chief economist to collect data to do greater research. But let's talk about your initiative regarding diversity. I know Representative Jackson Lee talked about this. Could you be a little more specific? I know you have not yet hired the chief economist, but certainly you can see the gaps or have identified, assessed gaps in diversity. Can you tell us specifically where are those gaps most chronically? I know you're going to be doing outreach and hiring a person for outreach, but can you identify where those gaps are in the creative world?
I think one of the big questions right now is finding out where those gaps are, and that is something that the chief economist will be very helpful with. Just to give as one example, I had always assumed, just based on my personal experience, that women were extremely well represented in the copyright world. And in fact, within the Copyright Office, approximately 60% of our employees are female. But it turns out that about 10 years ago, an informal study was done of copyright applicants, which concluded that actually women were significantly underrepresented among copyright applicants. I want to update that data. And I was at the PTO when the chief economist did a major research project on women in patenting, which showed even lower rates of participation than in the copyright system. So we need to get a better handle on what the current reality is, both for women and for minority groups, and also look at possible geographic underrepresentation. There may be a lot of creativity all around the country that is somewhat untapped because people aren't aware of what copyright is.
I think that's really valuable information that we should have. Maybe other areas of diversity as well, for example, folks who are disabled or differently abled, or however we want to say it, LGBTQ and others. What barriers are there to real depth of diversity in the taking advantage of the protection of copyright? So I honor the work that you do. Congratulations on your assignment. And with that, I yield back.
The gentlelady yields back. Ms. Bush. Does anyone else wish to speak? There seem to be no other members currently. Does anyone else seek recognition? Well, see anybody? Well, in that case, this concludes today's hearing. We thank Ms. Perlmutter for participating. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. Without objection, the hearing is adjourned.